All right,
I'm
folks,
sorry, I'm just getting
buckle
into
up.
this now.
What you're about to hear is not your average courtroom hearing.
My client or the
This is the story of
person?
Mr. Zenon, a man with a stack of prior
an
cases so
interference
high.
2 days ago.
It's practically
That's
a
what I'd
criminal
like to revisit.
resume.
Yeah,
10 previous cases,
so
dismissals,
you were on felony probation
deals, and now
for a
he's
very
back
serious case,
with a new assault charge, an active felony
evading
warrant,
arrest in a motor
and an
vehicle,
explosive courtroom
which carries
exchange
up
that
to
leaves
10
even
years
the judge baffled. The
in
defense,
prison.
claiming this is all
Nice,
just
pick up
misunderstanding
in
and vague law. The
Greg,
prosecution,
I got to
armed
tell you
with
that
body cam footage and a string of 911 calls.
I don't know
but
how
the real
much you know,
question
but
is,
I have
does the
quite
law
a bit of
actually fit
history
the facts?
with Mr.
And how do
Zenon
you
here.
charge someone with interference when
In
he
fact,
didn't even resist
within the
arrest the way
last
they claim? Stick around.
2.5
This one's full of
years,
twists, video evidence,
1,
legal
2,
loopholes,
3,
and a defendant who
4,
might have just gambled
5,
with the wrong courtroom.
6, 7, 8, 9. Now he's on his 10th case. Specifically, an unlawful carrying of a weapon. Another
Did you catch
unlawful carrying
that?
of a weapon.
We just watched the
Another
judge rattle
unlawful
off
carrying
a
of a
rap
weapon.
sheet like he was
Another
reading a
unlawful
grocery
carrying of a
list.
weapon.
Weapons charges,
Felony
marijuana
possession of
felonies,
marijuana.
assault on a
Felony
pregnant
assault of
person,
a pregnant
and this
person.
isn't even the current case. This is the
And I
context.
guess
And while
all
many of
that
these charges
worked
were
into a
dismissed,
deal where
probation
he got
was
on
granted
probation
and
for
deals were
evading.
cut. The
And now
sheer volume
we
here
have-
tells its own
Right,
story.
but all those
If you
cases
were a
were
judge,
dismissed, correct, Your Honor?
would you look at this man as a reformed citizen or a
Okay.
pattern
Pursuant
waiting to
to
repeat?
the, I guess-
Itself,
I
let me know
understand.
what you do in the comments
We
below.
literally had one after the
Understand.
other, like a rung on a step ladder. One after the other.
And-
So let's do probable cause.
Thank you, Your Honor.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I just wanted to give you a heads up of how much history we have with Mr. Zenon, because it's a lot.
I appreciate that, Your Honor.
Sure.
But be that as it may,
I'm not going to hold, I've never will hold anything against him. So let's go.
On December 3rd of 2024, officers were dispatched to the HEB located at 4955 State Highway 6 regarding a disturbance in progress. Officers received
So
4
now,
calls,
the
all
arresting
from
officer
witnesses
finds
who stated the
3.6
defendant
grams
was
of
arguing
weed,
with and
hears
assaulting
verbal
a female.
threats, and
While
watches
en
this
route to
guy
the
refuse to
location,
get in the
officers
car.
observed a couple
But
of
here's where it gets
intersections
messy. Is that
about
resisting
0.1
arrest
miles away
or
from the
interfering with a
HEB where
public
the original
duty?
call was
Observe
Because the
what?
law requires
They saw the
intent,
couple at the
not just stubborn
intersection.
behavior.
they saw.
The officer says
Okay.
he had to force
The
Zenon's
defendant
legs
was
into the car.
uncooperative with
But the
officers.
defense,
The
they say
defendant
it was
advised
more
he
like
and
the
the
defendant
complainant
going
were
plank,
involved in a
freezing
verbal
up,
altercation
not
and stated he
fighting.
threatened
This
her,
is
saying
where
he would
semantics
stop her.
become legal.
When officers
Ammunition. One
advised
side
the
sees
defendant that he was
obstruction,
in
the
custody
other
for an
sees
outstanding
hesitation.
warrant, he got upset and began to yell. Officers located a clear plastic bag containing 3.6 grams of marijuana. The defendant refused to comply with officers' commands to sit down and would not place his legs and feet inside the vehicle. The defendant pushed back against the officer's hand with his chest when he attempted to help him into the vehicle, pushed his legs straight and applied force toward officer's hand in an attempt to stop him from placing his legs inside the vehicle, and then used the bottom of his foot against the bottom of the door frame to further resist. The defendant refused to speak with officers and would not cooperate with the investigation. All witnesses on scene heard the defendant threaten to hit CW, and another witness stated she observed the defendant push the complainant in the chest and face with 2 open hands. He does have an active felony warrant from the Fort Bend County Sheriff's Office for aggravated assault with a deadly weapon
But he has an open ag assault somewhere else too?
in Fort Bend County, Judge.
my understanding is it's
And
an
it was
older
open
case.
warrant at that time?
Yes, Judge.
May I respond to all this, Your Honor?
Sure. Please.
Where's the interference? Okay.
Well, they're putting him in a car and he's
how-
like going
how-
plank.
It's not interference with public duties. If they're sitting there saying they have a marijuana charge they could have done, is it a resistance?
This right
Maybe,
here is where the
but it's
defense
not an
earns their
interference with the
paycheck.
public duty.
They argue
said
that
he
what
didn't
happened
talk, he
doesn't meet
have
the
to
legal
talk to them.
definition of
But- and
interference
they're-
with public
and they're a
duties.
mile-
And they're
0.1
not wrong to
mile away
push
from the
back
location.
because the law is
So
vague by
what?
design.
Well,
Just
okay, I
listen
get
to
that,
the
but-
statute.
so we have what
Interrupts,
we have.
disrupts,
We've got a disturbance at
impedes, or
HEB.
otherwise interferes.
Cops go there.
That could apply to
They start to
practically
talk to
anything.
him,
If you blink
and
too slowly, is that
I guess
impeding?
at that point
This is
says,
what
"Hey, man,
defense
I'm gonna
lawyers
slap
live
her."
for. Gray areas
So
they
at
can
that
pry
point,
open
I mean, that's what
and
we
argue
have.
reasonable
Right?
doubt.
Mr. Zenon, there's always 2 sides to the story. I get it. This is just probable cause. It doesn't mean that you're guilty of this offense. It's just probable cause. That, in and of itself, is it enough to continue an investigation? And it is, because it's a potential terroristic threat, right? So they have enough to go forward to investigate. They start investigating, and then they find that you have a felony open warrant And then they find, there was something else was there another warrant that you said?
No, it's the aggravated assault, but Judge, I also would like to point out that
But they end up putting him in the car. And at that point, he basically just goes plank like this for them being unable to effectuate an arrest.
And Judge,
You don't think that's an interference?
I don't. I mean, I think the intent of the law within itself is that if you're interfering with their investigation for something else. He did not interfere with anything.
Hold on, let's read the code. Let's read it. Because, I mean, there's no better way. Let's read it.
Hold on.
I'll give you, all right. Hold on. Let's pull up the code.
Intake could have taken some other things, but
Well, certainly they could have
Okay.
taken a whole myriad of, I mean, you're lucky they didn't charge you with assault of a peace officer. There's a whole host of other charges that they could have put on, you know?
but they didn't
Hit.
They took the one that I do not believe applies here.
Let's read the code.
Okay.
Let's see what
Did
the
you
code
hear
says.
that?
Because, you
The
know,
judge himself reads
there's
the
multiple
statute and flat
ways
out says,
that
that's the
a
vaguest
charge
thing
can,
I've ever heard.
you know,
When even the judge is
that you can
questioning the
charge
legal
someone
clarity.
with
You know this
facts,
isn't a
right?
slam
There's
dunk for the
multiple ways that
prosecution.
can-
Laws should
Right,
be
could have been
specific,
like a
not a
resisting,
catch-all net
you
you
know.
can toss over anyone who's
But-
being difficult. But vague laws give law enforcement a wide margin, and that's where abuse or
Okay,
overreach
you
can
ready?
creep in. Let's be honest.
A
Have you
person
ever
commits
seen
an
it?
offense
Law
if
this
the
open-ended
person
use
with
fairly every
criminal
time.
negligence interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law. Two, a person who is employed to provide emergency medical services, a firefighter. Number three, for an animal under supervision. Now, so I guess it's a person, it interrupts, disrupts, impedes, or otherwise interferes with, number one, a peace officer while the peace officer is performing a duty or exercising authority imposed or granted by law.
That is the vaguest thing I've ever heard in my life. I mean, come on.
It is. I agree
Okay,
with
so
you.
that the cop can claim anything is interfering with public duties. I mean, constitutionally, that is the vaguest thing I've ever heard of.
Judge, that's the statute, that's the penal code.
You'll find no argument with me, right? It is pretty vague.
Yeah.
It is.
He's got bigger issues. I mean, they should have taken the other charges, my whole point. I mean,
But he's disrupting the officer while he's trying to discharge a duty, right? The officer's trying to arrest him and put him in the car, and he's not letting him do it.
I mean, that's assuming they even had the right to do that. I mean, he's 0.1
It's an open
miles away.
felony warrant.
They didn't even know about the warrant. They didn't know about the warrant till after. So, I mean, that comes after all of this.
They're saying, go ahead. I didn't even give you a chance to talk.
No, you're okay,
Please.
Judge. They were investigating the assault, Judge, is what or the threat that he admitted to making. So it was an active investigation, and then when they were detaining him, he was resisting arrest, is what it seems like. And that's why it was charged with interference with public servant.
And there were also 4 911 calls that were made about this couple arguing. I
Mhm.
mean, that's what they were investigating.
And the witnesses all
They
described
put him,
the
I guess,
defendant.
did they put him under arrest at the time when he said that he was making
Now
that
here's
threat?
the legal landmine. Was the defendant already being arrested before the officers found out about his felony
And
warrant?
with the.
Because if
with
not,
I mean,
8.1
did
Then
they
what
have-
authority did
did
they
they
really
have
have
the
when they
authority
began
to
physically
arrest
forcing him
at
into
that
the
time?
car? This
Right.
matters.
So I think
You
it was
can't
during
arrest
their
someone first,
investigation,
then
the
justify it
defendant
after the
admitted
fact
to
by
threatening,
discovering a warrant.
that he
That's
would
not law
suffer the
enforcement.
misconduct.
That's
And it's at
retroactive
that point they
validation.
start to put him
Big
under
difference.
arrest?
At that point, they
Watch
ran
how
him
the defense
through
spins
the
that timeline
NCIC,
into
and they
reasonable
found that there was an
doubt.
active warrant, and then they informed him that he was in custody.
Okay, then that's a resisting from what they're using to say he's pushing back or
But
pushing.
remember,
That's
I
a
mean,
resist.
it-
That's not
it
interference
could
with
be-
public duties.
But it could be that a set of facts can be multiple charges, right? So it could be resisting, but it could also theoretically be interfering with what he's trying to effectuate with, which is an arrest. It's a duty that he's performing. He's performing the duty of an arrest.
But again, it's vague. If the officer didn't put in the report, he's not saying in the dim summary, you are under arrest.
We don't.
Well, I mean, it's,
Okay, well, I mean, but so
I mean,
this
we
is,
don't know. I mean,
okay, I'm just saying.
if he says he's under arrest, but I mean, damn, It's all but clear.
I mean, this is,
We also
And
don't
yes.
have the offense report
We
yet,
don't
I
have
don't
Judge.
offense
care.
report.
I
He
mean,
was in
but
the
I think that
process.
there's enough, he places him in custody, right? He's going to arrest him, starts putting him in the car, and dude goes plank.
I know, but I don't have the video.
I
I've
mean, I
shared the
think that-
videos with.
Remember-
You're right, I haven't had a chance.
Guys, this is a very low burden. This is probable cause. This is not beyond a
The
reasonable
judge brings
doubt.
the heat here,
You know?
reminding everyone that this isn't conviction.
Beyond a reasonable
It's
doubt
about
is a
probable
different standard.
cause,
This is
just
just
enough
to see
evidence
if
to
there's
keep the
enough
case
to go
moving.
forward.
And in that framework, even the
and
most minimal disruption
according
might
to
count as
this,
interference.
you are
But this also
disrupting,
shows the built-in
allegedly,
imbalance of power.
you're
The burden of
impeding,
proof for
and you're
locking someone in a
otherwise
cell starts
interfering
low.
with
So while the defense
him trying
argues
to arrest
technicalities,
you and
the
putting you
state
in the
only needs
car.
to nudge the needle forward. And often, that's all it takes.
A person can interfere with duties in multiple ways. It's not just one way. Like you go over there and someone else tries to stop an arrest from happening. I don't know. I think that there's enough.
Whisper to me because I want to know what you're about to say.
And if you want time, you guys can go back and talk.
Okay, well, I gotta say,
Required 3 times to search me.
can I have a moment to look at the video here? He's telling me a whole separate fact pattern.
But I need to give them time to be able to look at it too. I mean, it's noon. Why don't we do this? Why don't we roll it to Monday and we can, I'll find it now. We can reapproach Monday morning or tomorrow even. And if you find,
Because I
if
wanna
you
walk
find a
out.
completely set of different facts than to what they're saying on video, I'm all ears. I'm always all ears. I'm always willing to rehear probable cause at any time. I mean, it's not the be all end all. But for now, what they're telling me, if it in fact is the case, there's enough for probable cause to go forward. Is there enough beyond a reasonable doubt? I don't know. But be that as it may, okay, it looks like they didn't give him a PR bond on this.
Okay, so well, then we
The
address it.
bond right now is set at 2,500.
Okay,
Your bond upstairs is set at 5,000. Tell me about that Fort Bend case. Is it old? Is it new?
Let me check, Judge.
I think it's 2023.
Is it? I don't know. I mean, because it looks like you got on probation in October of this year. When you're on probation, dude, on felony probation, you have a freaking halo over your head. You got to be as good as you can. You're facing a lot of time in prison. Have you been to prison before?
Sir. No, sir.
It's not a fun place, and
Let's pause and
I
absorb
don't know
this.
what we need to do
A
to get
sitting
your
judge
attention,
just
man.
looked a man in the
This-
eye and said, if a person brings the worst out in
in
you,
life,
don't be with
if
them.
you're
That's
with
like
a
cancer.
person
And if you
that
don't cut it
brings the
out, it
worst
kills
out
you.
in you,
That wasn't
then
a
don't
legal
be
ruling. That was
with
a
that
human
person.
being trying to reach another
There's
human.
a
One lost in
gajillion
a
and
cycle
one
of
fish
toxic
in the sea.
relationships, bad
But how
decisions,
can
and
a
legal
person
chaos.
get you
Forget the
so
statutes
wrapped
for a second. This is real,
around
and it's heartbreaking.
your finger to make you, just go. It's like a cancer. When you have cancer, if you don't cut it out, it kills you. This is killing you.
I can contact Fort Bend Judge and get more information.
Well, it doesn't matter. It's neither here nor there. I'll do whatever you want to do. You want to set
I mean-
tomorrow, Monday,
I'll watch it today and come back tomorrow if you want.
Yeah, I mean, if you want. Surely. Do you have it?
We have the camera, or the body camera.
I just shared.
Okay, so
They
Let's-
shared it. They just shared it with me.
Yes.
let's roll it to tomorrow. You guys take a look at the video as well. Be prepared, and then we can reconvene tomorrow. For purposes of now, I'll find probable cause, and then we can regroup again tomorrow.
Okay, thank you.
Okay. All right, Mrs. Zenon.
Hey, come on.
See you tomorrow.
See you tomorrow. Probably gonna agree to disagree here. But I would like for you to watch like the 2 minutes of the video that I think.
So Judge, I also, because you had this question yesterday, I called Fort Bend and they confirmed it. The Fort Bend County aggravated assault with a deadly weapon, it's just sealed, and that's why I didn't pop up.
It's
for
just
it.
what?
It's sealed at the moment.
Sealed. Is it a new case? Is it an
It
old
was
case?
just filed in November, Judge,
Wow.
but the offense date was in March.
Okay, so that's what I'm asking. It was the offense date was March of 24.
Yes,
So it was allegedly committed prior to, now nevertheless, it's still a
it
warrant,
was,
but How on earth has it never been?
It's because, so they'll unseal it whenever an arrest happens, Judge. The case was filed. He had 2 other charges in this county, even that he caught even after that one.
I'm so confused. You know that Fort Bend knows that there's a felony warrant, a dangerous felony warrant, and they failed to execute that warrant over and over. He's been on probation. He's been meeting with his.
Reading in here that he's got on 2 years probation for, and then had also a UCW here that he caught after that. And another assault of a pregnant person that he caught here after that, and then another UCW that he caught here after that. So he had just a string of cases, and I mean, the list goes on. But there was just a string of cases that he caught even after that, so I guess they just never, I don't know.
I will tell you the shenanigans from my experience that Fort Bend does. So if they think they're going to TDC, I have seen them let them go to TDC, wait till they even make parole or discharge or finish that sentence, right? And then they're out and they go, oh, now we're going to file you. And then parole goes, oh, now we're going to revoke your parole. Those are the shenanigans that I've seen.
Judge,
and this has been going on for years out there, like prior administration continuing.
But I mean, I guess ultimately at the end of the day, even if that happens, like, let's just say the parole board's going to look and see that was like extremely old, right? I would have the first time he failed.
I'm not gonna read it. It doesn't matter.
Okay.
As in,
I mean, it doesn't matter. It's on video.
So I'll make a note.
Okay.
Insurance required, but note
correct.
if he
Right.
pays.
On video, guys. Like I watched it. I'm not crazy. Like this, it's on video.
Sorry to keep
Let's
waiting.
talk to Judge about it.
Okay. You're still upset?
Yes, I watched the video and I'm even more upset, Judge.
Now things get technical. The prosecution pulls out case law. Dandel v. State to counter the defense's claim that the interference statute is unconstitutional. And that's clever because they're doing the things, legitimizing their case while making the judge feel confident backing the charge. But here's the twist. Even with precedent, the prosecution struggles to explain what exactly Mr. Zenon did. That rose to interference.
I gotta
in your
imagine that
opinion,
if it
does
was,
this
if it
charge
was
feel real or like a
unconstitutionally
stretch?
vague,
Comment below.
someone would have challenged it and it would have,
Well, maybe they haven't had my case yet.
Okay.
and, I'm happy for you to make new law, always. Why are you saying that there's no PC in this case?
Is there PC for something else? Yes. Is there for the interference with public duties? No. I mean, because it's on video, it didn't happen, Judge. So they get calls for an assault, a disturbance, whatever.
You're telling me the fact that they're saying he goes plank in the car while
He doesn't.
being arrested
He
doesn't
does
happen?
not go plank. It's on video, Judge.
Would they say he uses his, I guess he uses
He's in
his.
handcuffs.
The officer has to place his hand on the chest of the defendant to get the defendant to sit back in the car. He also has to grab his legs and push them back into the car. We also watch the video.
We watched the video and we have a timestamp, Judge.
Could it be that okay, so I know that a lot of times when they're putting a defendant into the car, they need help, right? They're unable to do it by themselves, or is he actively resisting getting into the car?
He tried exiting the vehicle, Judge. And
No,
that's why they had to push him back into it.
He leans forward. He's yelling at his mom, record, call. The third time they have taken him out. This is 3 times. They put him in the car and they take him out so they can search him. The cop is sitting there going, oh, well, search him again. We can search him 20 times. If you feel you need to search him 20 times, search him 20 times for your safety. The cop doesn't even know what he's charging him with. DA hasn't been caught. The cop's sitting there go, we're getting you for resisting transport. Resisting transport. That is what the cop thinks he's taking of it. DA, Officer Singh, it's a 27-minute video. Okay? At no point is the DA's office called to this point. Okay? That happens after. Fine. For an assault, they can argue. I can argue case law. Ford v. State, specific articulable facts of crime may have occurred. Fine. They are there on an assault. Okay? They didn't take an assault. So then they detain him, right? They find that he has the warrant. So, okay, you're taking him in on the warrant. Fine.
Judge, it's
It's
common for officers to conduct an investigation before they call intake. That's not an abnormal
Yeah,
thing.
I mean, that's neither here nor there, but the question is he impeding the arrest or the function of arrest? Because I guess that you guys are basing the interference on the fact that he's not allowing him that, what's his name again?
Xenon, Your Honor.
Mr. Xenon is not allowing the officer to arrest him by putting him in the car.
Respectfully, Judge, the officer doesn't even have to be arresting him. They just have to be looking into any legitimate matter. And then he's interfering with that. And I will say, if he'd already been in the car 3 times, like defense pointed out, I would think he wouldn't need help getting in. So to us, it appears as though he's trying to push out. The officer has to put his hand on his chest to push him back into the car and then take his legs and place them into the car.
He was cooperative the whole time. He's on his mom. If anyone's aggressive, it's the cop from the beginning.
Judge, the
And
cop-
I ask at the court's discretion, watch the video. You only need to watch like 2 minutes, the 13 to 15 minute mark, Your Honor. I mean, that's all you really need to watch on this.
Judge,
Watch or no?
We can watch the video, Judge.
Cue it up. Let's watch. Can you put it on the screen somehow? So we can all watch?
we can just go to the back and watch it. Do you want to hook it up? I don't, because he has issues hooking his computer up to the technology. The whole video, or did you?
No,
want to
just the relevant portion. I don't need to see the whole thing. No, just that part that's relevant. You know, I guess if you wouldn't just put it right there and just turn it around.
Yeah, just put it
Just
up
right
there.
on the table. Yeah, right there. And set it.
I'm just turning the volume up, Judge, as well.
He talking about don't let him pull up. They talking about I got a warrant out for Fort Bend County for assault. Look, he pushing me. Mama, record me. Mama, look, record him.
Now you're under arrest.
I'm under arrest.
Yep,
for
you
what?
got a new charge, Bubba. Resisting transport.
Resisting? I wasn't resisting.
You just resisted transport. Yep.
What the hell is
So
that?
what did we
Listen, now you
just
gotta
witness?
charge.
A man with a checkered past caught in yet
Thank you,
another
Judge.
legal mess. This time over vague statutes,
Really?
unclear arrests, and
That's
alleged
it?
resisting
That's
that
it,
may
Your
or
Honor.
may
That's
not
the
qualify as
relevant portion of
interference.
offense
The
is
courtroom
Oh,
battled
come
through.
on.
Technical definitions,
officer is
blurry footage, and
investigating
human
legitimate-
I
emotion.
know, but
But in the end, the judge found enough
I'm with you.
probable
Do you see why I'm
cause
so
to
upset, Your
move
Honor?
forward.
Okay.
That doesn't mean guilt,
Thank you.
but it does mean Xenon's troubles aren't over.
Yeah, look.
And now, it's
yeah,
your turn.
I mean,
Do
you're
you
not
think
gonna
this
hurt
was
our feelings.
interference
You're not-
or overreach?
You need to do
Should past
what you
charges
need to
weigh
do.
this heavily in
Perhaps
court?
it was the wrong
Drop
one,
your verdict in the
but yeah.
comments. And
Was
if
it
you found this
resisting?
case as shocking as we did, make sure to hit that like button.
Nope.
Share
My
your
name is
thoughts
Bennett,
below.
and I ain't in
don't
it.
forget to subscribe for more jaw-dropping courtroom breakdowns.
No peace.
We're just
Thank
getting
you.
started.